Operation Crossfire Hurricane, or as it's colloquially known, Russiagate, seems to be the gift that keeps on giving. 6 years after its inception, and still it keeps making the news. This time it is a lawsuit filed by Carter Page, an informal advisor to the Donald Trump campaign. Recently, a district court judge for the District of Columbia has dismissed Mr. Page's case. The reasons why are both interesting and informative, making it worth taking a closer look. So we'll do that next on the Constitution Study. Hello there, everyday Americans. Paul Engel here with the Constitution Study. This is where we read and study the Constitution. We teach the rising generation to be free. Glad you could join me. I hope you're finding these episodes, the videos, the audios, I hope you're finding them useful and helpful. And I hope it'll drive you to the website, constitutionstudy.com, to find more information, maybe ask a question or support the work that we're doing here. I'll talk a bit more about that after the episode, but for now, let's talk about the current state of Carter Page's case. 2016 was a very busy year. We had the Flint water crisis, the Pulse nightclub shooting, and the presidential election. Now, while not the first time lies were used to impact an election, 2016 seems to begin the era of fake news. From the fake hacking of the DNC to the infamous PP tape, lies seem to spread faster than wildfire. In the middle of this was Operation Crossfire Hurricane. Reading from the judge's opinion. On July 31st, 2016, the FBI opened a counterintelligence investigation named Operation Crossfire Hurricane to determine whether individuals associated with the Trump presidential campaign were involved in coordinated activities with the Russian government. One of the targets of this investigation was Carter Page. According to Page, the FBI obtained 4 successive FISA warrants to electronically surveil him, despite there being no probable cause to suspect that he was a Russian agent. The defendant in this case, James Comey and others, asked the district court for the District of Columbia to dismiss the case on several grounds. Based on the evidence presented, though, it seems pretty bad for Mr. Comey and the other defendants. Continuing from the opinion. As alleged, the FBI's conduct in preparing the FISA warrant applications to electronically surveil Page was deeply troubling. Indeed, the government has conceded that it lacked probable cause for 2 of the warrants, and the Foreign Intelligence Surveillance Court has found that the government violated its duty of candor in all 4 applications. Similarly, Page alleges that the individual defendants intentionally provided false information and omitted material facts in all 4 applications. To the extent these allegations are true, there is little question that many individual defendants, as well as the agency as a whole, engaged in wrongdoing. But the defendant's motion to dismiss was granted. Why? Well, according to the opinion, even so, Page has brought no actionable claim against any individual defendant or against the United States. Now, as is so often the case, the devil is in the details. So let's take a look at those details. Now, the judge lists 3 statutory roadblocks to Mr. Page's case as justification for his opinion. Let's look at them individually. The first problem in the judge's eye is a question of standing. First, Congress has not created a private right of action against those who prepare false or misleading FISA applications. In short, when Congress passed the Foreign Intelligence Surveillance Act, they did not include the legal authority for private individuals to sue in this situation. Now, how can that be? Well, according to the judge, both the plain language and the structure of FISA make it clear that civil liability under 50 U.S.C. Section 1810 attaches only to those who conduct or perform electronic surveillance. Could that be true? According to Title 50, Section 1810 of the United States Code, an aggrieved person other than a foreign power or an agent of a foreign power, as defined in Section 1801A or B1A of this title, respectively, who has been subjected to an electronic surveillance or about whom information obtained by electronic surveillance of such person has been disclosed or used in violation of Section 1809 of this title, shall have cause of action against any person who committed such violation. The specific language of Sections 1810 and 1809 deal with electronic surveillance, not providing false or misleading information in order to obtain a warrant. Second, The judge states that the FISA law does not allow for damages from violations of constitutionally protected rights. Second, Congress has not provided for damages claims against federal officers for constitutional violations stemming from unlawful electronic surveillance in the national security context. I'm sorry, but that's just not true. While not in the FISA statute, Congress has provided for damages from any violation of the Constitution. Title 42, Section 1983 of the United States Code reads, "Every person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress." Now, as the judge has already noted, the government conceded that it lacked probable cause for 2 of the warrants and violated their duty of candor for all 4 of them. This caused Mr. Page to be deprived of his right to be secure from unreasonable searches by causing the court to issue an invalid warrant. Now, according to the 4th Amendment of the United States Constitution, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Furthermore, by providing false information under oath or affirmation on the application for the warrant, agents of the FBI have committed perjury. While this is a criminal charge, not a civil one, it certainly was used to cause Mr. Page to be subject to a violation of his rights protected by the Constitution. The last, in my mind, most egregious reason is this idea of sovereign immunity. And third, Congress has not waived the United States sovereign immunity for this kind of claim. Now, what is sovereign immunity? Well, according to the Free Legal Dictionary, the legal protection that prevents a sovereign state or person from being sued without consent. While courts may claim that the federal government cannot be sued without the consent of Congress, this would seem to violate the petition clause of the First Amendment, which reads, "Congress shall make no law abridging the right of the people to petition the government for a redress of grievance." Now, granted, Congress has not passed a law prohibiting the people from petitioning for redress in this circumstance, but by requiring that Congress explicitly allow such petitions in each and every section of the law, the courts have denied the people this right. This has effectively made Congress, and by extension the entire federal government, superior to the people. After all, what good is it to have the right to petition protected by the supreme law of the land if Congress has the power to allow or ignore it at their will? But what about Mr. Page's claim that the FBI misled the court in order to get a warrant? Well, from the opinion, when it comes to Page's core claim that the defendants misled the Foreign Intelligence Surveillance Court to obtain surveillance warrants without probable cause, the court cannot create a cause of action that Congress did not enact. Private rights of action to enforce federal law must be created by Congress. That's according to Alexander versus Sandoval. And courts may not usurp that power, no matter how desirable that might be as a policy matter. Any future remedy for these alleged FISA abuses must come from Congress, not this court. But what about the supreme law of the land? If courts cannot enforce the Constitution without the blessing of Congress, does that not violate the oath the judges took to support it? See, according to Article 3, Section 2, Clause 1 of the Constitution, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority. The judicial power of the United States is not limited to the laws of the United States created by Congress, but cases arising under the Constitution itself, which this one certainly is. I guess this is what happens when we allow the opinions of judges, euphemistically called constitutional law, to supersede the Constitution itself. While Congress did not include civil penalties under the FISA law for deceiving the court, they already exist in U.S. law under Title 42, Section 1983, since it has caused a deprivation of rights for Mr. Page. Furthermore, the claim of sovereign immunity deprives the American people of a method to petition for a redress of grievance, which violates the First Amendment. Claiming that the courts do not have the power to offer redress to violations of the Constitution is a dereliction of duty, which certainly is bad behavior in my book. I've not seen the suit that Mr. Page filed, so I'm not entirely sure if this problem rests solely with the judge. After all, if Mr. Page's attorneys did not realize that 50 U.S.C. 1810 only offered civil penalties for electronic surveillance and not deceiving the FISA court, bad on them. Since the judge did not mention any claim of violation under 42 U.S.C. 1983, I am forced to assume the attorneys did not make such a claim. Another reason why it is so important that, as John Jay said, every member of the state ought diligently to read and study the Constitution of his country. Remember, attorneys are there to counsel you, not to be the sole word on the case itself. I cannot say that I'm surprised at this opinion. It is pretty much what I've come to expect from our judiciary. Hopefully, this example will propel you into studying the Constitution and preparing yourself to defend your rights. Because depending on the legal system today to protect your rights is a fool's errand. So while I agree with the court that it cannot create a right to action that Congress didn't create, there's enough right there. Again, I don't know if it was the lawyer that missed it or if it was the judge that missed it, but I'm leaning towards the lawyer since the judge never seemed to mention 42 U.S.C. 1983. But again, we keep forgetting the lawyer, the attorney is not there to run the case for you. You don't hand it to him like a football and sit back and act passively. You are to be involved. They are there to counsel you. They are there to advise you. If you are not prepared to participate in your own lawsuit, you're at the whim of the attorney. And that attorney was educated through a system that doesn't study the Constitution. Now, maybe they just didn't think of 50 U.S.C. 1983. Who knows? Maybe this message will get to the attorneys and they can amend their complaint and try again. However you look at it, while this case may seem to be a minor little one, there is still good information and there's something we can learn from, which is really what the Constitution Study is all about. So if you want to find out more, go to the website constitutionstudy.com. You can find the text of this article. You can find other articles. You can search and you can even ask a question. If you just have a question about something, ask it right there. Maybe you'll support the Constitution Study. If you notice on the website, I don't have a lot of ads, no pop-ups. I've got a couple ads for people that I support, but I'm not earning money off of this. So it's all based on you and what books I can sell. Speaking of that, if you want a book, you can find that more under Books and More. All of it's right there at the Constitution Study. Also, you can listen to me 5 days a week on America Out Loud Talk Radio. Just go to americaoutloud.com and search for the Constitution Study. Now, however you do it, wherever you find this information, please do your part and share it. Let other people know about the Constitution Study. Let other people know the information that I'm providing so that we all become a bit more educated about our rights, how to protect and defend them. And if you would like me to come speak at one of your events, either as part of the Blessings of Liberty Tour or on another project, hey, just go to the website. You can find the request a speaker. I'll be more than happy to see if we can make it happen. So I hope you found this interesting. I hope you learned a little something today. Enough that you'll bring a friend next time for the Constitution Study.